guys, good morning, and good morning to Indianapolis. And if the volume's bad, let me know. I've switched things that the microphone connects to, but it sounds the same to me. Anyway, today we're going to look at, and I'll make this bigger in a second, this transcript in the Delphi case, and see what actually happened in it. Obviously, if you have an opinion that he's innocent, you might be tainted to think everything the judge did is wrong. And if you think he's guilty, you might think this is just the defense trying to exploit a situation. But the truth is usually somewhere in the middle. So we'll take a look at it. And I'm not going to hide the lead here. I think it is actually a bad situation. So anyway, before we run into it, let's talk about what we're talking about. I've got a couple of notes here. There was this purported withdrawal in chambers by the counsel, right, or intent to withdraw in Rossi's case. And of course, then they said, well, we'll appear pro bono. And the judge said, no, you're disqualified, which she did say, as you'll see in chambers, if we walk out of this room and you haven't withdrawn, you're getting disqualified. So there we go on that. And it says sound is off. Is it too low? Because I can raise it up maybe a little bit. You can say I just switched deals here. Anyway, this is supposed to be the same thing I was using before, except it's just a different version of it. I won't hold you up on that. So anyway, those are the things we're working with, right? Did they withdraw? Is that effective? Can they come back pro bono? Can they be disqualified, or was it handled correctly? And in this framework, of course, the defendant has a right to counsel, okay? But when it's appointed counsel, generally the law is you don't have a right to a choice of counsel. And that gets a little sticky. So if the judge switches the counsel, it's not necessarily a violation of your constitutional right. On the other hand, can the judge just do that for any arbitrary reason? I don't know about that. I think it can happen, of course, in some cases. Let's say the lawyer's showing up drunk, or the lawyer's got a book deal, or whatever. There's a fair trial element to this. But the judge generally, I think, according to the law I've seen, ought to weigh the factors. What's the conduct? What's the necessity for a fair trial? Like, what do you need for that? What's the cost of switching counsel? Delay, the rapport the defendant has. So there's a lot of mixed up stuff here. So I don't know if I've got the right microphone set. Hang on, I'm just going to check real quick. It's people over asking me that. And I can check that. Aha! It's not the right one. Thank you. Now tell me if this is making more sense. And thanks for pointing that out. Like I say, this is the first time I switched. It was a great time to do that without testing, right? Okay. So, let's see if I can see some questions here. And good morning to Scotland. Awesome. And I see a comment, what if the counsel wants to do it? I think it depends on what you're asking me there. But maybe, yeah. Okay, thanks. So I'm getting a report here that the microphone is working again. All right, so again, we're looking at the withdrawal, the pro bono appearance, the judge saying you're disqualified, and we're talking about the judge's ability to remove counsel, which the judge can do. And I mean, you can imagine circumstances where that would be the right thing to do. What if the defendant is, not very smart, maybe even has a competence issue, and the defense counsel is running around selling a book deal and showing up drunk and stuff like that? I think we'd all agree if, to get them out of there and get a different lawyer in. But on the other hand, if the judge just doesn't like defense counsel being aggressive, we'd all agree that's not fair. So somewhere in the middle is real life, and we'll look here and see where this leans, I think. The normal reason for disqualification out of a case is conflicts. And while that might have been hinted at a little bit here, I don't really think that exists here. Now, ideally, the judge would have a decision on the record. The judge would state the disqualifying facts. The judge would balance the interests, the Sixth Amendment right, the cost to the defendant of losing counsel that he wants, that he already has, what justifies that, and make an analysis of that, and then give the decision. And that way, if it does go up to a higher court like it has here, that court has something to look at, and something that is justified potentially. So good morning to Denmark. All right, and let's see here. Nicholas says, I read the transcript and I'm furious, but won't spoil anything. Well, I don't know about if I'm as furious as you are, but that we may have different underlying opinions of the case, but I also know you're fully capable and do analyze this on a procedural basis, and that might be the genesis of all your fury. And I don't like it either. That's the short version of this, but let's Okay, so yeah, so here's the further point of this. If she took the counsel off and the defense says, hey, we'll do it for free, which is basically hired counsel but free, they're not appointed anymore, why should she remove them? Well, here she says they're worthy of being disqualified, and that's what she told them. So let's see what she has to say. I mean, I don't see it myself, but we'll see what you guys think as we move through this pretty quickly. I've highlighted, ideally, the portions that I think are most relevant. So they get going with the small talk, and I think it's worth noting that Rossi says, remember Rossi and Baldwin were the defense attorneys, and Rossi does most of the talking in this. Baldwin seems kind of flummoxed. I mean, when I read this transcript, I could almost see the emotion coming off. I could see Baldwin kind of slumped in his chair, disappointed that the situation had occurred. Someone had taken things out of his office. Now he was in this problem. He called it, I think you'll see, a low point in his career. Rossi's trying to navigate this, but he doesn't think what's happening is fair. The judge has had enough of it. The prosecution certainly wants these guys going. Like you can, if this had been televised, I think there'd be some drama to be seen in this, and all we get is the black and white. But I think you'll see that. So Rossi says, I'm the one who kind of asked to huddle up. That's interesting. So they were going to go into court, and as you will see in this, apparently the plan was the judge was going to disqualify these guys. She'd already made that decision. Whether she was going to let the state put on the planned potential evidence / exhibits they had to allegedly support this, I don't know. That would be some further dunking, I suppose, but that didn't end up happening, of course, as we all know. Now, having said that, if there were evidence that justified disqualifying them, you would want that in the record, right? But as you'll also see, the defense says, shouldn't we at least know what's coming first? Okay, so let's get into that. So Rossi says, I'm the one who asked to huddle up. And they've got the recorder going, so we're okay there. We'll get to the good parts here. And Rossi's basically saying it'd be great to get some of these motions decided. And also we're a little bit worried about the word disqualification. It was murmured in the phone conference we had a couple of weeks ago. And that raises the intensity level of the circumstances. Yes, it does. Now let's look in here, I think, is a material point. You know, it makes me, this is Rossi talking, it makes me a little uncomfortable because I don't know, there are no pleadings that are pending, whether they're motions to disqualify or contempt citations or whatever there might be that frame any of the issues. So Rossi's concerned is he's coming into this hearing, he doesn't really know what the scope of it is and really what's going to happen in this thing. Does that seem unfair to you? Should you know before you go into a hearing what the hearing is really about? Kind of what the scope is, and if the other side is potentially going to present evidence against you, should you have some knowledge of that ahead of time? And that seems fair to me. That seems fair. If, for example, you couldn't do that because of exigent circumstances, the judge could always take it under advisement and allow the defense to respond, but that was not what was going to happen in this case. So, yeah, it read like a telenova script. Good morning to the UK. All right, so we'll skip some of this. I know that there are people who've read this whole thing online, so I won't do all of that. But the first salient point is Rossi's bringing up, I think, an important issue, which is, shouldn't we have some notice of what's going to be going on today? Like, what is actually happening here? And then they talk about the fact that maybe you're talking about we're going to get disqualified, Judge. You said I'm leaning in that direction, and the judge agrees with that. So the judge had told them on the phone, I think we knew that from some of the other records, that, you know, I might decide to disqualify you guys. And Baldwin says that's a cause of concern because we're still wanting to try this case in January. I mean, this is only a couple of months before the trial. And I think whether you think the guy didn't do it or he did do it, or you just don't have an opinion because you don't know what all the evidence is and you can't figure it out yet, for everybody's sake, the sooner the better on this thing. And this change of counsel is a high cost to the whole system, to the victims' families, but also to Alan and his family, because it's going to pad on another year in addition to public costs. So it really should be justified, I think, to take these guys out of the case. Let's see. Nicholas says, I got the notion there's been off-record discussions between the judge and the prosecution. Well, I hope not. I hope not. But if there has, they should be able to find that out. But there were, there are, and you probably know this, emails in the record that were copied to all of them where they did discuss some of these things by email in a very informal manner, which, that can happen. That's okay in and of itself. But when you get to a crux issue like, I'm going to kick you off of the case, I think it's time to get more formal than that, and with some fair notice, I think. Anyway, so Baldwin says he'd like to take this case in January, and that hints to an important thing, which is if you switch counsel, that comes as a high cost to the defendant and everybody else acting in this case, anybody with a concern over it. Cases dragging out when they don't have to isn't good, really, hypothetically, for anybody. If you're out on bail, maybe, because maybe you'd be opening the witnesses die. Sometimes you do want to drag a case out for that reason. But he's in prison, and so he's not wanting to drag it out. His attorneys were ready to go. All right. So the prosecutor, McClellan, here says they were going to give the court a summary of the investigation. It's important the court hear these things. And I think the importance of you hearing it is outweighed by other considerations. And here's where the state says, I'm concerned the leak is not just a one-time leak. The evidence that we have shows it's an ongoing leak. However, it's being done, and it's just what's next. I have an issue, what's next? So if that's true, if that were true, that there's this ongoing leak process, and that's going to be a reason for the disqualification, then you should agree with the state that ought to be on the record, okay? But you might also agree with the defense, but we should be able to see what it is you're talking about so we can rebut it before the moment you actually say it. But these attorneys end up being said to be disqualified. I don't think any of this stuff gets on the record, okay? So if the state has a good point here, where does it enter the actual evidence? And if it doesn't, it shouldn't be used as the basis for disqualification. So then Rossi says, this is starting to scream due process to me. I've not seen these exhibits. I don't know anything about this. And I think this is going to be important as we look at this, is Rossi and Baldwin are two different people in two different places. Is it fair to impute, let's say Baldwin did the last couple of mistakes, or intentional or gross negligence, whatever. He's the actor. Does that get imputed over to Rossi? And if in theory it was that bad to throw Baldwin off, could you have salvaged this by leaving Rossi on the case? That wasn't an option, as you'll see. Anyway, he says it's starting to scream due process. I'm not seeing these exhibits. I'm not distancing myself from Mr. Baldwin, but I have no connection with any of these people, okay? The idea that somehow the prosecutor is going to roll out a bunch of statements and exhibits and testimony without us having any forewarning or any idea, scrutinizing that seems outside the boundaries of due process to me. Man, that sounds reasonable, doesn't it? So prosecution's allegations should be tried in court on the record. Well, right. I mean, if you're going to throw the guy off of the case for what the state is saying, then that needs to be said on the record, and they should be able to rebut that. Otherwise, you can say, well, state, I understand your position. It's not part of my analysis. That would, potentially be different, but then it gets a weaker case on disqualifying these guys. So, all right. Now, Rossi tries to make a point here, and does make somewhat of a point. He says, I've got 10 pages of a deposition transcript. It took a trooper Holman in his case, and he talks openly about how there were crime scene leaks from the very beginning, unequivocal crime scene leaks as soon as the crime occurred. They were lay people that were part of the search party. So now I don't think, and he talks about how law enforcement is trying to catch up with him. Lay people part of a search party talking, let's be fair here, is not the equivalent of either the prosecutor, the sheriff's office, or the defense leaking out information. So that's not persuasive to me. But he does make the point down here where he says that Barbara McDonald's been on different shows talking about she gets information from investigators. And I don't know if that's truthful or not. But Rossi's point here is that the other side hasn't been exactly squeaky clean on providing information, not providing information to the public. But I don't equate searchers with law enforcement in that aspect. But I think the broader point that, okay, so law enforcement has put its theory of the case in the public, that's true. But while Rossi's trying to advocate his position, leaking crime scene photos, that's just bad. That's bad. Does it warrant disqualifying? I don't think so in this situation, but it's not good, okay? So, and even attorneys have due process rights. Yeah, the prime due process right here, there really is, of course, Allen and his interest, because if the lawyer's terrible or really doing terrible things and stuff, then the judge can kick them off the case. But it should be on the record. I think that's the idea here, and probably what you're trying to say too. And I agree with that. So they talk about, Baldwin talks about how there's people all over the planet saying they have all this case information and all of that. Who can really know? But look at what he does say here. Honestly, this is the lowest point of my career right now, because somebody did what they did to me, and I know that has nothing to do with Richard Allen, and the court agrees it certainly does not. So I can see Baldwin kind of sitting in a chair there, realizing that he's behind the 8 ball because this information came out of his office, and now the judge is super steamed over it. And I don't think she liked these guys before that. And so Rossi didn't do that. So he's going to be more the aggressor here trying to defend a situation. But you can see Baldwin is like, this really sucks. And I agree with all that. And I see crime scene images were out before all this happened. I hear all that. But again, there's rare in the legal system is there one side 100% right and one side 100% wrong. And if you have confidential discovery in your possession and you allow it to get out, the judge is going to look at you and potentially do something to you for that. And it's not necessarily an excuse but other people were doing things. Now, I mean, if you could show that thing was out in the public, man, that can be a defense to some degree, maybe completely, but you'd have to show that. The thing is, you have an obligation to treat the discovery confidential. But I think the answer to that was how he was doing this super bad. It's it's not like he dropped it on a bus or something like that. He had it in his attorney's office. There was another lawyer or somebody with a JD or whatever there who he thought he trusted, who went in there and took pictures of it. That's not, if that's how it happened and that's how it's said to happen, that's not the worst way discovery has ever leaked out before in terms of culpability, because sometimes, of course, they just email a link out accidentally and all of a sudden all the discovery's out there. And that seems a lot worse than what happened here, I think. So the point is that if other information has leaked, it doesn't absolve them from doing wrong here. But I think, you could make a point that it's mitigating. The question is, does this rise to throwing both of these guys off the case? Anyway, we move on past that point because we may not fully agree on that, but that's okay. I think the result we are agreeing on. And let's get down to, they talk about actually some of the subpoena things and stuff like that. Some of it goes for the state, some of it goes for the defense. Okay, so this is what the judge says. I write everything out, and this is what I intend to say in open court. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. So that's kind of lawyer language there of weighing the balancing, which I talked about in the first part when I was trying to fix the microphone about ideally on the record, you'd have a weighing of the interest. So you'd recognize under the law what the interests are, an interest in continuity of counsel that Allen has, his right to counsel, the cost of switching counsel in terms of delay, his rapport that he has with counsel. Those were the, some bad parts of switching out counsel. And then you look at what are the acts that support switching out counsel. Did they have a book deal? Are they representing some of the odious secretly and they didn't tell anybody? Of course, those things aren't true, but I'm saying that probably warrant disqualification, right? But what are the acts that they did? Each one, I think, not necessarily both. And you weigh those things. So she's saying she's, weighed the totality of circumstances. Let's see what she says about that. Candidly, my concerns began our hearing on November 22nd of last year. There was a motion for a gag order in chambers, and the defense says, we don't want the media in our lives. We will not try this case in the media, but less than 2 weeks later, you issued this undated press release. Has an awful lot of information not normally revealed. Well, I mean, the press release was a piece of advocacy, and maybe they should have done it, maybe they shouldn't have done it, but that was also a long time ago, and it also wasn't the craziest thing anybody's ever seen either, right? So, okay, so that's her thing one. Then, to be fair, if it is a bad thing, I think that counts against both of them. Is it really a bad thing? It's subject to debate, but it's both of them. And she says you may have been violating the rules of professional responsibility there. And she says potentially. So there's no finding here that violated the rules, right? You knew or should have known that it was potentially violating Rule 3.6. Okay. Potentially. I'm potentially speeding if my speedometer's wrong, and I don't know, right? Or maybe I should know if I look at, that's different than saying you did the thing anyway. So she says that made me grant this gag order until further hearing. Okay. Then you filed a notice of tort claim against the Department of Correction. Yeah. You stated in that notice that it was your intent to pursue our client's claims against you. The full amount of damages sought on behalf of my client is unknown. I don't know how you could do that in representing Mr. Allen in a criminal matter and launch off into a civil matter. I thought that was a reservation of rights letter, though. And sometimes you have to do that within a certain amount of time to keep a tort claim open against the state because of some sovereign defenses. I don't know all the law up there, but sending a notice to somebody is a long way from actually filing a lawsuit against them. So I don't know that representing the guy saying he's innocent is a conflict with saying you're going to sue the Department of Correction for how they might have mistreated the guy or unfairly done things to him. It kind of does seem consistent. And if they're going to try the case in January, it doesn't appear they were filing any civil action until after that. So again, I think that maybe you count that against both guys, but is it really a bad thing? Yeah. All right. And then May of this year, we were notified by the state of the Brandon Woodhouse arrest. Subsequent discovery of your work product, I think it was an outline that you created for yourselves with the discovery. Pretty detailed. Apparently that happened in December. It was not revealed to anybody, not shared with the court. And then Baldwin says he didn't know. I'm sure he's talking there about Rossi. And the court says, well, you knew. And Baldwin says, I did know. Okay. So here's thing 3. Okay. That's a mistake. Apparently he sent the email to somebody that had the same first name and he shouldn't have sent it. And it was an outline of discovery. I don't think it had super confidential stuff in it, but, it happened as what should have happened, but Baldwin did it and Rossi didn't. And Baldwin says, Rossi didn't know, and the court doesn't contest that. So you got 3 things, 2 of them against, Baldwin and Rossi to the degree they're bad. And then the third one is just Baldwin. And I think Rossi's kind of clean from here on out. So if I'm doing this right, we'll see if I've missed one. What you really have against Rossi is this press release of the Tort Claim Act, and then months later he's thrown out of the case. So here we are. So she says grossly negligent to email that to the wrong Brad. And that could be. I mean, who in the modern world hasn't seen an email or a reply go out to people that like, that should not have happened. And you can call it negligent or grossly negligent. And those things don't mean intentional. Like he didn't send it out on purpose. The court is saying that it was negligent, that you should have really looked at that line before you sent out this confidential information. And of course, you always should. But there have been several high-profile cases, several recently that you probably know of, where attorneys have sent discovery links and sometimes discovery and things like that out in a way that they shouldn't have, that allowed people to get access to it that they shouldn't have. I think there's a struggle there with the volume of information out there now and keeping it confidential. It doesn't make it right when you do it. It's also not the first time that it's ever happened. But again, Rossi didn't do it. So you got 3 things hypothetically on Baldwin and 2 on Rossi. Then she says this one, which is a little bit strange for me. Your pleadings in the safekeeping order contain inaccuracies and falsehoods. That was proven in a hearing we conducted in June. The evidence presented by the state clearly demonstrated the falsity of your claims. That's very troubling to me. So I think she's talking about the one where they wanted to move him, and they talked about, he's a prisoner of war, he's sleeping on the floor, how horrible it is. Now, I had to get my world's tiniest violin out for some of the things they said. That's not saying that I disagree with their point that if you could, he should be put in a closer jail rather than prison, because I pretty much agree with them on that. But it also doesn't mean that every single thing they said was super serious and exactly right. Some of it, in my opinion, was almost silly and overwrought in how they were writing this and talk about telenova stuff. Some of that was a script for that. But the attorneys were that it was false. That what they did was false. Why weren't they sanctioned at that point? And attorneys not supposed to file false pleadings with the court, right? But of course, defense attorneys and any attorney, but sometimes in the cases I've talked about recently, you see them put forward theories that may not be factual, like Adelson and his payment plan hit people. You can't pay now? Well, we can do easy payments for you. Tiny ninjas, things like that. Just she liked to drink Visine. So, I don't know about that. And that seems pretty unfair to bring that up now, unless that was sanctionable at the time as a reason to throw these attorneys off the case. But I was wrong in my count, because that would go against both of these guys. So you'd have another one there for them. But I think that is the end for Rossi at that point. But this one, it almost doesn't register on the Richter scale to me. That seems kind of unfair to bring that in at this point, to me. Then the last couple of weeks what we've been dealing with. The discovery is severely compromised, and I don't know that we know what all was photographed out of that room. We have the discussion about what hypothetically was leaked out and appeared. Is that the full scope of it? Who knows? Don't know, I don't think, because it didn't get put on the record. And if you're going to use it as the basis to disqualify him, maybe that should be known so it could be reviewable. And then there's this ongoing investigation. Everyone involved has sought counsel, including you, Mr. Baldwin. You've had an attorney enter a written appearance. And it is interesting. Baldwin and Rossi said he did give, or Rossi says he went down to the police and gave a statement to the police, waived his rights and all of that. And if they did violate the order, it's possible they could be sanctioned under it. So it's a pretty serious set of charges, but do you go from there to throwing both these lawyers off the case? And remember, if the stuff photographed out of Baldwin's office and put out by somebody else is serious enough to disqualify somebody, should it be the basis to disqualify Baldwin and Rossi? Because up to this point, you're not disqualifying anybody. So how was Rossi responsible for that? So when you kick Rossi off, you're now going to delay this case for an entire year. I think that shows the court had enough of it and didn't like these guys for a long time. That's really what this chain of events tells me, is she's been rubbed the wrong way for quite a long time, and is pulling all these things back in to say, well, I'm going to take you off of the case for the aggregate of all of these things. But have you seen anything in here so far about this totality of circumstances, about the cost of this? Like, on the other hand, it's going to delay us for a year. I got to think about that. I got to think about this. Right now, what you're seeing here is the alleged acts of the defense counsel that justifies removing them. So she says, it pains me to say this, but the totality of the circumstances demonstrate gross negligence and incompetence on the part of the defense team. And incompetence, I'd heard the gross negligence. Incompetence is an important word. You can't have an incompetent lawyer just sitting there letting somebody get convicted. Is that what this is, though? Is that what this is? It's not incompetence in the theory or really the presentation of their case alleged here, except for saying that they were false in some of the things they said to try and get him out of the prison. But really, the incompetence is the bad email and the pictures taken in the conference room, right? Those are the incompetence, if it is that. And if that's incompetent, how's that Rossi? Because he didn't send the email and it wasn't his conference room. Okay, he wasn't there to even know that Baldwin was letting somebody walk around his office. So how do you get both of these guys in this if it is that bad? So the judge says, I'm gravely concerned about Allen's right to have competent, non-negligent representation, and there's your start of your balancing, right? He currently doesn't have that right now because what you have demonstrated is negligence and incompetence. I'm sharing my thoughts privately. I don't want to say this in open court. I would encourage you to talk privately about what you wish to do. So she's thrown down the gauntlet there, right? You're negligent, you're incompetent as an attorney. And if you could justify that on the record, then the attorney should be gone. Who thinks that a defendant should have incompetent appointed counsel? Anybody going to agree with that? I don't think so. The question is, do the facts support that or not? Or is that a conclusion she reaches because she's tired of these guys and she wants them off the case, as some people seem to think, and I might be in the category of some. So Baldwin says, I'm not good at reading between the lines, which he obviously had just read between the lines. And the court says, you're a lawyer. That's what you do for a living. And Baldwin says, well, when you say have a private conversation, are you talking about the four of us? She says, I'm talking about you. I'm not accusing the state of gross incompetence and negligence. I'm finding gross incompetence and negligence with you. Rossi steps back in and says, obviously reading the tea leaves here, what you're giving us a chance to do is bow out gracefully, if you will, if that's the right term. And here he put something I think is important on the record. Is there a scenario where the court would accept if I stayed in the case? I'm a team player, and I'm not the kind of guy that just bails out on somebody for the sake of doing it. But I think it's obvious that, and he can speak differently, talking about Baldwin, I'm not as connected to some of the, most recent circumstances as he is. Yeah, Mr. Allen is in a situation where he's going to have counsel. If he has new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in. And I think his Sixth Amendment rights matter. And I'm probably the one that can move this thing forward with some sense of judicial economy. I don't like it. It's not what I intended to do when I came in here, but that would be the worst case scenario on our side. Is that an option that the court would entertain? No. But why not entertain it? Because there is a cost there. There is this year delay, and Rossi wasn't responsible for the conference room or the email. No, there's no entertaining that. And so then Rossi says, you're saying you either quit on your own accord or make me fire you. She says, I'm not saying that to you. I'm just saying I plan to say in court on the record when we convene at 2 o'clock. This is what I'm going to say. And then Rossi tries again to get a clear answer. The culmination of that is you're removing us from the case. And then the court answers clearly, I will, based on what I just shared with you. So there's your answer. That's cool. You know what the judge is going to rule before you even go into the room, so that's cool. Looking at some comments here. All right, let's get back on this. So now we know what the story is. Rossi cannot stay in the case. The judge says, nope, not going to let you split up. You're both out of here. So Rossi's alleged terrible things are the Tort Claim Act, the trying to get him out of prison pleading containing false things in it potentially, and then whatever the first one, the press release. So those are the three things Rossi's done that I'm aware of. And he's thrown off of the case for that a couple of months before trial, and then it gets delayed for a year. And it seems a slightly extreme there. And I think it was good of Rossi to get that on the record, although I think he was also probably sincere in it. Like, look, if you're determined to kick somebody off, can you just do one of us so that we can move on with this case? And somebody says maybe this was just a delay to take the attention off. The thing is, I think this got the attention on. And I feel like, is the judge, I was asked, is the judge corrupt? And to me, the idea of corruption, the way I'm going to define it, or I see it as corrupt, is when you're doing a bad act and you're doing it because you get something out of it, either in conspiracy with somebody or you're being paid or whatever. So it's none of that for me here. But I would find it hard to argue if you put the position up. The judge had gotten sideways with the defense counsel a long time ago, had no tolerance left for them. And when she got the chance to take the shot and it really angered her about these pictures coming out, she did it and got them out of there, because she does go back through the history of this thing, picking out things that I don't think justify disqualification and putting them in to be part of the totality of the circumstances. She's human. And, sometimes your reasoning is swayed by how you feel about people. That's an attribute that you would like to be minimized as much as possible when the person we're talking about is a judge. And of course I could be wrong on it, but that's kind of what I'm reading out of this transcript. Now, here's Rossi talking again. Allen has communicated it to us that he does not want us to withdraw from this case. He wants us to continue with his representation. He knows he doesn't have the authority to force the court to do that, but he would like to say it on the record. We asked him if that's what he wanted to do. And we suggested maybe it be in chambers because they're not out in the hearing yet. It seems a little bit of a difficult position to put a man who's been accused but not been found guilty, put him in a courtroom and have him speak on the circumstance with 15 minutes notice. And then Rossi says, I'm going to file a motion of withdrawal. I don't want to do it, but I don't think I have a choice at this point. And of course, they ultimately don't talk to Allen about this. Rossi says, I think if we'd been given some notice of what we were actually, if this would have been framed in a pleading format or some formal disciplinary claim where there's a process for that in our business, then we could have come in here today with an opportunity to refute some of those things that you clearly had thought through and prepared before we got here. We didn't have that opportunity. Me going in there and standing my ground because my client wants me to is just going to make things worse for him. So I'm going to withdraw my appearance. I'm going to walk out of here, go down to my car, call my staff and have them prepare a motion, and I'm going to withdraw my appearance. Now that's quite clear that he has not withdrawn his appearance because he says he's going to do it. Right? It's like a New Year's resolution. You can say it, but it doesn't mean it's accomplished. All right. So, and then of course, a couple of days later, he said, I'm not going to do it. And then the judge, that put the judge on the spot, ultimately come out and say, well, you're disqualified, which has got this thing up at the Indiana Supreme Court. Let's see here. Then Baldwin says, I'm the same withdrawing. I mirror what he said. I do appreciate giving us the advance notice. If there's some appreciation for that, I do appreciate that. But beyond that, I want to take this and finish it out. I'm stunned. I don't know what to say. So I'll just say I'm moving to withdraw orally. So he does that under the same circumstances as Rossi announced his intention to withdraw. Is that an effective withdrawal? And if you withdraw as appointed counsel, can you come back pro bono? And if not, why not? Why can't the guy have counsel of his choice if it's not paid for by the state, if it is basically privately retained counsel that's pro bono? All right. Then they argue about what they're going to do with discovery. What do you want us to do with Mr. Allen? And the court says, I'll take him back to the Department of Correction. Do you want to make a record of this? Rossi says, I think it's appropriate that the court let him speak into the record his thoughts, unless the court just accepts that as notice that those are his opinions. The court says, well, you wouldn't lie to me about that. And that would have been nice to see that or hear that or be in the room for that. You wouldn't lie to me about that. That's different than saying you wouldn't lie to me, right? You wouldn't lie to me about that. Does that mean you might lie to me about other things, or is that putting you on the spot for it? And then Rossi, of course, maybe he took it the way I'm saying, because he says, I would not lie to you about anything. So then the court says, well, of course, there's your representation. And that's what he would say if he were brought in here. Therefore, they don't need him in here. I can't imagine the DOC being comfortable bringing him into my office. I would not be comfortable having him in my office. I'm thinking having this hearing be one that they were going to have blown out on TV and everything was not the right time to have a big television camera in there if all this stuff is so sensitive. Because in theory, you should have been able to bring him into the courtroom and let him talk. And the stuff should have been resolved in the courtroom, in my opinion. Even the withdrawal stuff. They should have talked about that. They could have come into open court and they could have said what they wanted to say, have Allen say what he wants to say. And that isn't what happened. So, and I think that's because the judge didn't want that to happen. Or else that's what would have happened. And it would have been, but you don't know what they might say, right? So that's basically the end of the transcript. So you have the situation of this history of things, right? That the press release, the tort claim thing, the trying to get him out of prison thing that these guys did. Are those things you would throw a lawyer off a case for under the theory that they're grossly negligent or incompetent? Now, if you think they're violating the gag order, or if you think they filed something false with the court, there are sanctions for that. Are those things incompetent toward the defense of Richard Allen? I mean, even if you believe that he did it, would you say that's incompetent, though? Or maybe it's aggressive, right? Maybe it's aggressive. Now, sending an email to somebody that shouldn't get it and letting somebody get in your conference room and take pictures, that's not aggressive lawyering. That is negligent, right? Okay, so that's bad. You're not supposed to do that. And it doesn't matter if other people did it. It's still bad, okay? But how bad is it, right? When you're a couple of months from trial, how bad is it? You could have done a lot of things there short of what happened. You could have put Baldwin on notice. If this happens again, I'm going to put you in jail for contempt for 10 days or something like that. And he would have said, understood. He wouldn't have said that. And he wouldn't have done it or allowed it to happen again, I think, anyway. You could have, hypothetically, as Rossi said might be the worst case scenario, kick Baldwin off the case, keep Rossi. And she said no to that, too. So she throws them off the case, disqualified under these facts, and then appoints counsel, which one of them, if you're all worried about the media and stuff like that, one of the new counsel, as you know, had done interviews about this case on TV. Now, he wasn't prohibited from doing that at the time, but if one of the factors you have is you guys are out there making statements you shouldn't make, is it ideal to bring in a guy who's made statements about the case? And again, not that he did anything wrong, but if that's so bad, then why would you bring a guy in who had done the same kind of act? Granted, he's not under the court order, but if it's bad, I would hypothetically want to pick people who had made no public comments about the case, particularly if said comments could be construed as potentially favorable to the state. So that doesn't seem ideal either. Now, I saw somebody ask a question on Twitter, not to me, but somebody else. Can this take years to resolve because of it's an appeal? But it won't, because it's a writ and it's original jurisdiction to the Indiana Supreme Court. So as you probably know, this is happening quite fast. One response is already in, And then the response to the other action, which is about the disqualification and the removal of the judge, her response is due on Monday. I think it's this coming Monday. So far what she's done is put all the things essentially on public record that the defense asked for in their first action. She's released this transcript, which was another thing they asked for. Hey, the only other two things they've asked for is reverse this disqualification and get this judge off the case. Are they going to sweep the table? I don't know, but the judge will have to, or should have at that point now, a response coming this Monday that details why she thinks that the Supreme Court shouldn't do either of those things. And it is also possible, as pointed out to me, that the AG had asked for clarity that they could file a brief this coming Monday, and that likely will be opposing, or should be opposing, whatever Allen is saying. Some of it or all of it. Doesn't mean it would be all of it. We just have to see what position the AG wants to take. I think they probably have an interest in how the law goes in terms of retaining some discretion to remove counsel for things like that, and they may have something to say on that, or whether they go full-throated in favor of the judge. So there'll be very interesting pleadings in this case coming early next week, I think, because you'll have hypothetically the judge's personal response through her attorney, and then the state's response to this whole thing as well. Yeah, the comment there from Nicholas is the AG's not representing Judge Gull is somewhat telling. I kind of thought, well, sometimes they do, sometimes they don't, but they have said that they want to file a brief in this case. But normally I would say the AG's brief would be fully in favor of the judge. But in that case, why have her even bother to go on out there and get her own counsel instead of appointing somebody from the AG's office? And it may be because the brief that they're going to file would not be, may not be exactly how the judge would want to present her side of things. So I'm certainly, when I see these pleadings next week, I'm going to look for discontinuities between what the judge is saying the result should be and what the AG's office says the result should be, because there could be some space, but some air between those two things. Maybe. Things that happen in the AG's office can be kind of strange sometimes. So while I think it's fair to read those things into it, we won't know for certain until next week, but then I think we will know what all that is. So the law is a little more complicated on this than, you want it to be, as law often is, because there is some power the judge has to remove lawyers off the case and disqualify them off of the case. And you have less rights with appointed counsel than you do with hired counsel. But then Rossi and Baldwin came back in and said, well, fine, we'll be retained counsel. The defendant's rights increase at that point. You have this alleged incompetent finding by the court. Negligence is one thing, and whether negligence in sending an email is enough to kick a lawyer off a case is another. But what's the incompetence here in terms of defending Richard Allen? I didn't really see that in the record. So it'll be interesting to see what the judge has to say about this. So I read this, and I thought this might be more inflammatory than it was, but there's more emotion in it than I thought I would see. And it's clear to me now that the defense, while I don't always take them or the state at their word, gave a reasonably accurate rendition of what was occurring in chambers, that the judge cited these factors and said, you're terrible, and I'm throwing you off of the case, and I'm going to walk out there and do it unless you withdraw for this case. That is what happened. That is what happened. And I don't think that's the appropriate way to handle this. So I just don't think so. I think either the Supreme Court needs to throw this back to her and say, your order doesn't have enough information in it for us to assess it and sustain it. You need to restate your order with whatever your grounds are, or just go ahead and reverse this order and say, the sweet spot there would be that you have X amount of discretion to change out appointed counsel because there's more latitude for that. But for privately retained counsel, and these guys have decided to come in pro bono, that they don't have a real conflict of interest, then you can't stop them from being his counsel under these circumstances. And those seem to be the right results for me. And whether the judge should remain on the case or not, I think if these guys are on the case, it'd be hard to say that they're going to get along, and there'd be a fairness there between them, viewed reasonably from the outside. The judge might be able to throw it out of her mind and proceed, and that's fine. But you're also supposed to look at it as like a reasonable observer and say, is this going to be an impartial situation? So I'm not a fan of Richard Allen's defense in terms of their theories and things, and because I think the circumstantial timeline against him was not really addressed to my satisfaction. I think it's pretty bad to him. I understand some people see that quite differently, but I'm with the defense on this. I think this is an unfair result, and that Rossi and Baldwin were advocating for him zealously, like they're supposed to do, and they didn't do it perfectly, at least in some cases. And I don't think they should be thrown off of the case for this. So let's see what we got here. What are the limits to the powers of the judge controlling who represents the defendant? Yeah, it's a good question. And that is a question that is argued across the nation with different parameters in every state and every jurisdiction, even depending on which federal courts you are in. Because while you have a right to counsel, and it can be a counsel of choice under certain circumstances, even that the court can have some control over if there's a substantial conflict or something like that, obviously, because the judge can't let a fraud be perpetrated upon the court or let a defendant be convicted with incompetent counsel just standing there. So it's usually a conflict that results in somebody being disqualified out of a case. Now, when it's appointed counsel, the defendant has less rights to continuity of counsel than they would if it's privately retained counsel. But that got thrown into a little bit of a disarray here when Rossi and Baldwin said, well, we'll become privately retained counsel pro bono. We'll just do it for free, and let's get this case over with. So we may explore what Indiana feels like the limits are. I looked at a case this morning and didn't have time to analyze it for notes for this one. This seemed pretty favorable reading of Sixth Amendment stuff for the defendant that was in Indiana Court of Appeals. So I'm going to try and look at that a little bit more this weekend, this question you're asking, because really it's what are the limits and powers of the judge controlling who represents the defendant in Indiana, because it's not exactly the same all around the nation. But generally speaking, you can't do an arbitrary act. So if the judge just comes into court one day and says, you're off the case, even if the judge has power to take a lawyer off the case, that usually the exercise of a court's power, of course, is supposed to be based on something that gives them justification for it. And so even here, you can't be completely arbitrary or completely wrong. So there is that limit regardless. The judge said a turn of events seemed upset. Her affect came out. The camera didn't match what this transcript shows. Yeah, I agree with that. What happens if she's removed? Well, they'll put another judge on it. So now this whole thing from a procedural standpoint is a disaster. It's theoretically possible that she could be removed off the case and then still not be allowed on it. I don't think that's going to result, but this is like an epic level mess, and it would take some thinking to try and consider what the probable outcome is. And usually I try not to invest but so much energy in that because we don't have both sides' arguments yet, and they're going to research the case law, and I look at it a little bit, but nobody's paying me to do that. So in theory, they will do a more diligent search than I will. So I'd like to read the pleadings that the AG has this coming Monday, and the judge has their briefs in response, and then compare that to what has been filed. And then we have what the Supreme Court will have at that point in terms of making a decision. But I'm still going to look at it a little bit before the weekend. I can't help it. I'm looking up some cases. It's just what lawyers do. What does this mean for Richard Allen appellate issue? Well, kind of not really, because it's already at the Indiana Supreme Court. So let's say hypothetically the Indiana Supreme Court were to say, what is in this transcript justifies removing these lawyers from the case and disqualifying them and keeping them out, and the judge is fine to stay on the case. So it goes forward, he gets convicted. Who's he going to appeal to? Is he going to go up to the Indiana Supreme Court and say, hey, you guys were totally wrong when you did this? So by bringing the issue up now, I think this is kind of his appellate issue for this situation, even though it's a writ rather than any kind of normal appeal. But I think they're doing the right thing, clearly, to try and do it right now. I mean, that's what you should do. If you think this mistake is now and it's critical for this guy, then do it now. And they are doing that. Yeah, a Facebook friend part of this. So it's interesting because, the bars wrestle with this a little bit in terms of judges having Facebook friends with lawyers, and different jurisdictions take different views on that. My view is Facebook is evil, and I don't like it. But, it may be okay there as long as she's not like coming over to his house for barbecue all the time. But it all depends around here, at least. We used to do things with the judges. The judges are elected. They show up for personal appearances and things like that. And they're also people. So you might do social activities with them. And I used to shoot sporting clays with a judge all the time because we like to shoot. or ride motorcycles. Some of them were Harley fans and stuff. So, you know, like I say, a good lawyer knows the law, but a great lawyer knows the judge. And it is always a good idea to do that. But Facebook puts it right in everybody's face, doesn't it? But of course, we all know Facebook friends doesn't mean you're a friend. That has no connotation that you're actually a friend with somebody. So again, I think it depends on the jurisdiction you're in. So that's my take on this. Is I think the judge shouldn't have done this, and I'm kind of with the defense on it. And we'll see. This brings up, I say, a lot of legal issues, and I will try and I've made some notes now and try and do a better job of the legal part of this on this weekend, because I got a couple of days that I can look at different things while I'm working around here. And this one was to go over the transcript and see the basis for this thing, which to me doesn't match the outcome at all. And I, of course, can't read this from Nicholas, but boy, does it look pretty cool. I do recognize the young thug, which apparently translates the same all around the world. It's probably okay for them to be friends since they're defense lawyers, not prosecutors. It really is a thing, as I say, ethically in different jurisdictions about what judges do on social media and what they can say and whose book they can say is a good book. And you can be friends, but you can't be, liking all these posts. There's some ethical drama on that for judges. I don't envy them for that. And if I were the judge, I would try to stay off of it as much as I could. But then on the other hand, if you're elected, you want to keep getting elected. So she should have had the hearing. Yep, totally. That's a 100 right there. In fact, that could have been my whole stream this morning. But she should have had the hearing. And then it would be on the record. And the actual thing supporting the decision would be there. And we could have an opinion about it. But if it gets taken up to the Indiana Supreme Court like it is, they would have the record that shows it. So we have kind of an ersatz situation of how this order developed, but at least now there is something in black and white that shows the basis for it beyond the parties trying to say what the basis for it was. Yeah, well, right. It's not their friends that bugs me. It's out of all the lawyers she could appoint. Why those two? And that's a good question. That's a good question. And maybe she didn't, know that this guy had been on TV and stuff like that, but it kind of looks bad to hold it against these guys that they made one press release favorable to their client. And then this guy did an interview that was kind of favorable to some degree to the state. Again, I don't think he was doing anything wrong. He wasn't on the case at that point, but I have an opinion on that. That's for sure. But I would agree without getting into it that it looks bad. Yeah. This comment right here. She shouldn't have appointed attorneys that have publicly commented on the prosecution's case. Right. Especially if one of your grounds for disqualifying these dudes is publicly commenting on the prosecutor's case. Well, I don't want to string it out any longer than it has been, but it's a fun discussion. But I hope you guys can come back for the weekend, and we'll get into this in a little more general theme. And the case that I found this morning, I'll talk about that and see if I find other Indiana cases, because the Indiana Supreme Court will look for prior authority in the state, because that's what appellate courts do. They like to have a continuity of their decisions, stand on precedent, look for that for guidance so they don't give contradictory orders. I think this is slightly novel, but I still think it tilts toward the defense. That is definitely my opinion. But anyway, I hope everybody has a good day and is getting ready. If you celebrate it for Thanksgiving, and celebrate that. And I also celebrate the free days that come with it. But I'll hopefully see you guys this weekend. Thanks. Bye.